been over 2 years since the U.S. Supreme Court handed down one of the most significant Second Amendment rulings in American history, the Bruen decision. It didn't just shake up New York, it changed how every court in the country, including courts right here in Idaho, look at gun laws. So, what does that actually mean for Idahoans today? Well, my name is Bob. I'm a retired cop, firearms instructor, a Second Amendment activist, and this is the Idaho 2A News.
For Idaho and liberty!
Now, before we dive in, if you care about your Second Amendment rights here in Idaho, hit that like button, subscribe so you'll never miss an update, and share this video with a fellow gun owner. June of 2022, the U.S. Supreme Court ruled in New York State Rifle and Pistol Association versus Bruen. On the surface, it struck down New York's restrictive concealed carry permit law. But the bigger impact was the test the court laid down for every law in America, every gun law in America going forward. The court declared that any regulation affecting the right to bear arms must be rooted in the historical tradition of firearm regulation in the United States. No two-step approaches, no spirit of aloha. It must have a historical analog. Period. Courts must now examine laws that existed at or around the time of the founding, 1791, to determine the will of the people, what the will of the people was when there were very few gun restrictions. If an exact law or a close analog didn't exist back then, a modern restriction may not survive that legal challenge. This is a massive shift, and it's being felt in courtrooms across Idaho right now. Now, Idaho was already one of the most gun-friendly states in the nation long before Bruen. Idaho adopted constitutional carry, no permit required for concealed carry, and as of 2020, any U.S. citizen or active duty military member who can legally possess a firearm can carry without a license. Idaho has no assault weapons bans, no waiting periods for firearm purchases, and a strong preemption law that prevents cities and counties from passing stricter gun rules than the state has. So you might think that Bruen doesn't change much here, but here's the thing. It actually does. Because Bruen isn't just about carry permits. It's about every gun restriction in federal and state law. And Idaho residents are showing up in federal court as test cases that will shape this law for years to come. The most striking example is a case called the United States versus VanDyke, and it's an Idaho case right here. See, in May of 2023, Ryan VanDyke walked into a state courthouse carrying a loaded Smith & Wesson .38 revolver. At the time, he was subject to a civil protection order and a no contact order, and he was facing a felony stalking charge, all stemming from his alleged harassment of a woman trying to escape his contact. He was indicted for illegal firearm possession under the federal law that prohibits gun possession by someone subject to a domestic violence court order. VanDyke's defense: that under Bruen, even that federal gun restriction had to be justified by historical tradition, and he argued that it wasn't. Now, Idaho Federal District Judge Lynn Windmill agreed and dismissed the federal indictment, finding that, as applied to VanDyke, the law didn't fit within the historical tradition required under the Second Amendment under Bruen. Now, here's where it gets interesting. The Ninth Circuit, they stepped in. The appeals court reversed, holding the federal statute constitutional as applied to VanDyke. Of course, it's the Ninth. Reasoning there is a historical tradition of disarming persons deemed dangerous, including those facing serious criminal charges. The case was sent back to the Idaho District Court for further proceedings. This case is a perfect example of what Bruen has unleashed. A federal judge in Idaho, applying the Bruen test faithfully, concluded a domestic violence protection order wasn't enough to strip somebody of their gun rights. And then the Ninth Circuit, relying on the Supreme Court's 2024 follow-up in Rahimi, they reversed that. And this is the legal tug of war that's now playing out right here in Idaho courts. And VanDyke is just one piece of a much larger wave. By 2024, the number of gun cases heard annually has risen to 680, compared with just 74 in the entire decade before Bruen. The Idaho Supreme Court ruled that private organizations can ban guns on public property, even though cities and counties themselves can't, sparking a legislative push to restore what gun right advocates called gutting firearm preemption. So the Bruen test sounds simple. Does a historical analog exist? But in practice, judges across the country are struggling with it. For Idaho gun owners, here's the bottom line. Idaho's own state laws are in solid shape under Bruen. Our laws already reflect a strong Second Amendment tradition, but federal prosecutions involving Idaho residents, unresolved questions about protection orders, challenges to the felon in possession statute mean that Idaho courts are going to be busy with Bruen-related cases for years. As Attorney General Labrador put it, the meaning of the Second Amendment must remain consistent across the nation and not shift with state borders or circuit court lines. Whether the Supreme Court continues to tighten or broaden the Bruen framework will shape what gun rights look like in Idaho for decades to come. My friends, we're going to be tracking every major case as it develops right here on the Idaho 2A News. If you found this video helpful, drop a comment below. Let us know what Second Amendment issues you want us to cover. Like this video, subscribe, and share it with somebody who needs to hear this. I'm Bob, and remember, the most dangerous thing you can be, armed and educated. Stay both, and we'll see you next time on the Idaho 2A News.